Good afternoon. My name is Anthony Randazzo, and I am an executive partner at Secrest, Wardle. Today I'll be conducting a webinar on the application of the Recreational Land Use Statute in Michigan. The first couple of questions you all may be asking yourself is, what is the Recreational Land Use Act and why do I care? Well, for most people, they don't care. But if you're one of the fortunate ones who are landowners, lessees, tenants, or who insure those individuals, you may want to listen up to this webinar because the Recreational Land Use Act may provide you with an absolute defense to that cause of action. What is the Land Use Act? The Recreational Land Use Act in Michigan is defined by statute MCL 324.73301, and it states, except as otherwise provided in this section, a cause of action shall not arise for injuries to a person who is on the land of another without paying to the owner, tenant, or lessee of the land a valuable consideration for the purpose of fishing, hunting, trapping, camping, hiking, sightseeing, motorcycling, snowmobiling, or any other outdoor activity, recreational land use, or trail use, with or without permission, against the owner, tenant, or lessee of the land, unless the injuries were caused by the gross negligence or willful and wanton misconduct of the owner, tenant, or lessee. Now, at first glance, the statute may seem to be quite straightforward. However, as the saying goes, especially in the law, looks can be very deceiving. However, before we get into the minutia, let's understand why the statute was created, because it will certainly help us understand how the act should be applied. So why was the statute enacted? Well, for most private landowners like me, they're generally unwilling to open their land for public use, simply for the reason that someone at some point in time will get hurt and sue them. I'm a lawyer. I know lawyers, and if someone gets hurt on my land, I will expect a lawsuit to show up in my mailbox. For this reason, I don't like people crossing my land or using my land in any regard. My goal, quite frankly, is to exclude the universe from my property. However, that goal runs contrary to the prevailing public policy of this state. You see, the public policy of this state is to promote the open use of a finite resources that we all know as land. And that land is best used if the public is able to use it for recreational land use activities. The Recreational Land Use Statute was formulated to resolve the competing interests of property owners in public policy, essentially, as it was devised, to promote the public recreational land use of privately owned land. The statute does this by granting landowners, tenants, and lessees a broad immunity from liability from injuries suffered by land users pursuing recreational land activities on a particular owner's land. Now, the statute only applies, however, if the injured party did not pay the owner for that particular use. Similarly, the Recreational Land Use Statute does not apply where the owner, tenant, or lessee was either grossly negligent or acted willfully and wantonly. Once again, the underlying policy of the Recreational Land Use Statute is that the public's need to access land for recreation is somewhat greater than an individual's need to keep that land private. So to promote the land use access to the public, the statute in the state has provided immunity to land owners. Now, you have to realize a statute is important because it is a breakaway from the common law. Under the common law, or judge-made law, a landowner owes certain different duties of care to persons who enter upon his or her land. Under the common law, or judge-made law, the duties will depend on their status as a invitee, licensee, or trespasser. Under the common law, the greatest duty of care is owed to an invitee. The duty to take reasonable care to protect against unreasonable risks of harm caused by dangerous conditions on the land. On the other hand, no duty is owed to an unknown adult trespasser except to refrain from injuring that person by willful or wanton misconduct. The Recreational Land Use Statute changes the common law in certain circumstances. In particular, under the statute, all recreational land users, including minors, are treated the same. They are essentially treated as if they are all trespassers. So the only duty is to refrain from gross negligence and willful and wanton conduct. Now that we have taken a look at the breakaway from the common law, let's get into the statute a little more. Let's look at the application of the statute in its historical form. Much of the application of the Recreational Land Use Act has focused on whether the type of land involved in a given case was of the nature that should be protected by the Recreational Land Use Statute. In this regard, there are two views on how to apply the Recreational Land Use Act. Again, the historical view, as we'll get to in just a second, and the modern view. So let's look at the historical approach as called out in a case entitled Weimer versus Holmes, 429 Mich. 66. This is a 1987 case. This is a case that actually involved two separate actions that were consolidated for appeal purposes. The first case, again, is Weimer versus Holmes, and the second case is entitled Yarling versus Bell Lake Association. Let's first take a look at the facts of these cases and then examine the holding. In Weimer's, Linda Weimer and her 6-year-old daughter were visiting the home of Linda's sister and brother-in-law during the Memorial Day weekend of 1981. Linda's sister and brother are defendants in the action. In the back of the defendant's home, there was a man-made pond. While the parents, including Linda, were inside the house, children were outside playing near this man-made pond. Now, they were playing near the pond in the shallow area, catching pollywogs in a bucket. After some time, the children returned back to the house to play up near the house, all except Linda's daughter, Jennifer. Jennifer continued to play at the water's edge while her parents were inside, and unfortunately, Jennifer drowned in the pond. Subsequently, Jennifer's father brought suit against the defendants in this case, arguing that the defendants failed to warn Jennifer that there was a drop-off in the pond where his daughter had drowned. Now let's look at the facts of a consolidated case of Yarling versus Bell Lake. In that case, plaintiff Yarling was invited to a birthday party at the home of Mr. and Mrs. Granis. Once at the party, Mr. Yarling was subsequently invited to another party in the same subdivision at the Bernowski home. The Bernowski property was continuous with a private park in the Bell Lake subdivision. The park abutted a lake, which was also part of the park area. When Mr. Yarling arrived at the Bernowski house, one of the swimmers, who was familiar with the lake, ran down a hill at the edge of the lake and made a shallow dive to enter the lake. That swimmer then called attention of Mr. Yarling and asked him to join him at the lake. As such, Mr. Yarling, without hesitation, ran down the same hill to the water's edge, and he jumped in. And unfortunately, he dove into 14 inches of water, causing him to sustain very significant injuries, leaving him paralyzed from the shoulder down. The lake was owned by the entire subdivision, and subsequent to the injury, plaintiff brought an action against more than 200 defendants, including the Neighborhood Owners Association and individual lot owners. Okay, so these are the facts of both the cases. So the next question is, what did the Michigan Supreme Court have to say about the facts and whether or not the recreational land use applied to bar either of these actions? In both cases, the Michigan Supreme Court was asked that question. Let's determine the applicability of the recreational land use statute. In doing so, the court looked at the plain meaning of the statute as well as the facts of the respective cases. And in both cases, the Michigan Supreme Court held that the Recreational Land Use Act did not apply to either action because the language of the Recreational Land Use Act, read in light of legislative history, was intended to apply only to, quote, large tracts of undeveloped land suitable for outdoor recreational land uses. The Weimer Court put a significant limitation on the application of the Recreational Land Use Statute. In particular, it relegated the use of the statute as a defense to only large tracts of undeveloped land. Thus, it did not apply to situations such as the case in Yarling and Weimer, where the land was subdivided into smaller tracts of land. The Weimer's decision came down in 1986. That was the law for nearly a decade. That was, of course, until the Supreme Court revisited this issue in a case called Neel v. Wilkes. 470 Mich. 661. Again, this is a 2004 case. Now let's look at the facts in Neel and compare that with the facts of the earlier decision in Weimer. In Neel, plaintiffs sustained injuries while driving an ATV vehicle on defendant's property. The vehicle was driven by defendant's brother on defendant's property. When defendant's brother drove over a piece of uneven land on defendant's lawn, plaintiff was bounced from the ATV, causing severe injuries to her back. Defendant's property was an approximately 11-acre lot that was zoned residential. So this was a subdivided area, zoned residential for residential use. And although portions of the lot were wooded, plaintiff sustained injuries while riding the ATV vehicle on the portion of defendant's backyard that was actually mowed. It was the residential part of the lawn and of the property. At the trial court level, the trial court granted defendant's motion for summary disposition, stating that the Recreational Land Use Act did not bar the cause of action. And that was because they looked at the decision in Weimer's. Because in Weimer's, remember, the Supreme Court stated that the Recreational Land Use Act only applied as a bar to large tracts of undeveloped land. So, the initial courts in Neel decided to follow that precedence and not allow for the application of the Recreational Land Use Act. And that decision made its way up to the Supreme Court, where the court reviewed the case and the Court of Appeals interpretation. And in particular, the question that the Supreme Court looked at was whether or not limiting the applicability of the Recreational Land Use Statute to only large tracts of undeveloped land. In reading the plain meaning of the statute, the Neel court held essentially that the Weimer's court got it wrong. In fact, the statute itself, they suggested, placed absolutely no restrictions at all on the size of land. It placed no distinction on whether the land needed to be large versus small, developed versus underdeveloped or undeveloped, vacant versus occupied, land suitable for outdoor recreational activities and land not suitable for recreational activities, urban and suburban, rural and subdivided or unsubdivided. There is nowhere, anywhere in the statute that places any specific limits on the type of land that needed to have such a character such that the Recreational Land Use Statute would apply. Put simply, the type of land was not a condition preceding to applying the statute. So, the Supreme Court in Neel held that they weren't going to read any such limitations into the statute, as it would run contradictory to statutory construction and interpretation. In short, the statute contained no such limitation, so no limitation was going to be applied. Therefore, an owner is not liable to a non-paying outdoor recreational land user unless the injuries are caused by owner's gross negligence or willful or wanton misconduct. That has nothing to do with the type of land upon which the recreational activities were being performed. This is not a threshold requirement. This, again, is a huge change in the case law from the Weimer's decision 10 years earlier. And that would be all types of landowners could take advantage of the Recreational Land Use Statute, not just those owners of large tracts of land. If we look at the statute, the legislature points out different types of activities, different types of recreational uses in which the statute would apply. In particular, the statute specifically sets forth such activities as fishing, hunting, trapping, camping, hiking, sightseeing, motorcycling, snowboarding, snowmobiling, and other types of activities that are similar in nature. This is a common catch-all. A common catch-all to the Land Use Act is that certain classes of similar types of activities will be considered as part of the definition of outdoor recreational use, such that the Recreational Land Use Act should apply. If we look back to the Neel decision, the Neel court really relied upon the doctrine of ejusdem generis, which is Latin for the same kind. In particular, when a general term follows a series of specific terms, the general term is interpreted to include only those things of the same kind of the last character of nature specifically enumerated. As you saw in Neel, the court found that riding an ATV was of the same class of character as the enumerated activities specifically identified in the statute, such as, for example, motorcycling or snowmobiling. However, it should be noted that no court to date has gone on to specifically limit the types of activities that would fit the statute. This is important because we have a situation where it's at least arguable that if something may be an outside activity, it may fit the definition of outdoor recreational land use or something similar as cited in the actual statute, that you could argue application of the Recreational Land Use Act. Okay, now that we've looked at situations in which the Recreational Land Use Act would apply, I would be remiss if I didn't at least talk about situations in which the landowner would be liable or the act would not apply. The first situation where the Recreational Land Use Act would not apply is a situation where the injured person actually paid valuable consideration for use of land. It's very important. If the landowner, tenant, lessee is paid for the use of their land, then we are not in a situation that you could apply the Recreational Land Use Act as a bar. The statute specifically states that in such situations where valuable consideration is paid, the statute does not act as a bar. On this point, Michigan cases has uniformly held that to meet the valuable consideration requirement to void the statutory bar, the payment has to actually be paid for the use, the particular recreational use in question. So if you are paid, you will lose the Recreational Land Use Act as a defense. The second situation in which you will not be able to take advantage of the Recreational Land Use Act as a bar to a particular suit would be a situation where the landowner, tenant, or lessee acted grossly negligent or willfully or wantonly causing plaintiff's injuries. Now again, you might be saying, what does that mean? Well, gross negligence is defined as conduct by the defendant that is so reckless as to demonstrate a substantial lack of concern for whether injury resulted to the plaintiff. Willful or wanton misconduct is defined as conduct that shows an intent to harm or such an indifference to whether harm would result to be the equivalent of a willingness that it does. In those few situations, you are not going to be able to take advantage of the Recreational Land Use Act as a defense to a cause of action. These situations are, I guess, somewhat easy to imagine. Let me give you a quick example. Growing up, my father was an absolute fanatic with his lawn. He hated neighborhood kids playing anywhere near his lawn. It was his prized possession. And given how our yard was situated, it lent itself to neighborhood kids constantly coming onto the lawn with their bikes. The area in a certain particular portion of my father's lawn no longer was able to grow grass because of how often these kids would be riding their bikes on the lawn. If my father wanted to prevent that sort of conduct, and he went out in the backyard one day all mad, and he started digging holes where he knew these kids would be riding their bikes, and he covered those holes up with grass or whatever to conceal the holes. And those same neighborhood kids came riding their bikes, they usually did, and fell and injured themselves on the concealed holes. Well, I think my father would be considered to have acted grossly negligent or willfully or wantonly to not enable him to use the Recreational Land Use Act to bar the claims of any injured neighbors who fell into holes that he created. So that's one example. I'm sure there are a host of other examples, but that kind of gives you a flavor for situations where the landowner's conduct may prevent the application of the Recreational Land Use Act as a defense. Now let's switch gears for just a minute. Some of you may be interested in whether the Recreational Land Use Statute provides an exception to governmental immunity. Some of you may be governmental entities, insured governmental entities, and see this as a potential problem given the language of the Recreational Land Use Act. In particular, the fact that there are statements in the Recreational Land Use Act as to when the act doesn't apply, such as when someone is paying for use of your land. Because oftentimes cities, municipalities will allow individuals, entities to use their land for payment. So again, the question is whether or not some of the language in the Recreational Land Use Act and its applicability, does that somehow create an exception to governmental immunity? Now, I can just rest assured it doesn't. It does not create any exception to governmental immunity. Remember, Recreational Land Use Statute is a very general statute that provides general protections to landowners, tenants, lessees of land when their land is being used for certain purposes. However, governmental immunity is a very specific statute. It is a more specific statute that protects governmental entities, and the rules of statutory construction are such that specific statutes will trump general statutes. So in this case, the more specific governmental immunity statutes will prevail over the more general Recreational Land Use Act statute. And it's also important to note that because you have a specific statute, if the state legislature wanted to carve out an exception whereby they would be liable, that governmental entities would be liable and not be able to take advantage of their specific governmental immunity for payment or for other situations, the governmental immunity statute would have identified that carve out in the specific statute, and it just hasn't. Or those that they have done are specifically outlined within the statute themselves. Now, this very issue was addressed by the Supreme Court in 1988 in Ballard versus Ypsilanti. And again, the court there reiterated that the statute, the Recreational Land Use Statute, does not create some type of an exception to governmental immunity. While we generally think of using the Recreational Land Use Act as a defense to bar premises liability claims or claims that sound in premises liability, in 2015, the Michigan Court of Appeals decision reinforces the fact that Recreational Land Use Act may apply to any cause of action, not limited simply to those causes of action that sound in premises liability. The case I'm referring to is a case entitled Schoenbeck versus Kelly. This is a 2015 case, and while it's unpublished, it is persuasive authority in Michigan and will likely be filed by other courts of appeals in this state, as well as trial courts, given the fact the decision comports clearly with the plain language of the Act. In Schoenbeck, the plaintiff was injured when he was struck by a cable gate while riding a dirt bike on property that was owned by defendant property owner and at least to two other defendants who were the lessees of the property. In that case, the lessees installed a cable gate on the property, which was the instrumentality of the injury. However, in that case, plaintiff did not sue any of the defendants in premises liability. Rather, plaintiff sued all three defendants for negligence and gross negligence. Nevertheless, the same three defendants moved for summary disposition based on application of the Recreational Land Use Act. In response to the motion, plaintiff claimed the Recreational Land Use Act did not apply because the Act only applied to premises liability actions. In reviewing the case, the Court of Appeals agreed with defendants and held that the plain language of the Recreational Land Use Act states that the Act may apply to any cause of action and not just those actions that sound in premises liability. The court further noted, if the legislature of this state wished to limit the application of the statute to a narrower set of circumstances, it could have done so, could have used those words, and it could have limited in such a way that the Recreational Land Use Act only applied to premises liability, but it didn't do that. Rather, the Act states that it applies to any cause of action. A cause of action which is more broadly defined and does not limit itself to a certain set of circumstances. Again, the Recreational Land Use Act may be applied, at least insofar as the Court of Appeals in Schobeck is concerned, to any cause of action. Why is this important? This is important because we cannot let labels on claims in a lawsuit dictate our defenses, especially when we're concerning ourselves with the Recreational Land Use Act defense. When we see a claim that is being brought where there are factual allegations that may give rise to application of the Recreational Land Use Act, we ought to be pleading it, the statute, as an affirmative defense. And under Michigan Court Rule 2.112, special pleading of matters, we are required to identify specific statutes and ordinances to the extent we want to rely on those as either part of our claim or, more importantly here, as part of our defense. So you should be thinking to list it regardless of the names of the causes of action being placed on the complaint or in the complaint by the plaintiff. We look at the factual allegations, and if those are such that the Act may apply, we should be listing it. Now I want to go over some recent developments in application of the Recreational Land Use Act over the past few years. The first thing I want to talk about is whether a situation is such that a landowner only has a possessory right in property, whether or not that landowner may take advantage of the Recreational Land Use Act. And the Court of Appeals in Wardle, Pittman versus Pincato held that, yes, if in an unpublished decision, the Court of Appeals held that the landowner with possessory rights to a lake may invoke the Recreational Land Use Act as a defense, even though that particular landowner did not, quote, own, end quote, the lake, where the particular plaintiff in that case had drowned. So an important recent development shows us that mere possessory rights in property may afford that landowner and may avail himself of the defense of the Recreational Land Use Act. Next, there was a recent case in NASH versus Duncan, and the question there was whether or not an individual, an 11-year-old boy, who was killed and hit by a fallen tree while sledding, whether the owner of that property would be able to take advantage of the Recreational Land Use Act. And there it says, the Court of Appeals stated that they may be able to take advantage of the Recreational Land Use Act because the case is nothing more than a mere negligence case where a plaintiff was engaged in an outdoor activity without paying, and thus it applied. And I think here we look, the distinction here that we should be looking at is the court went to length to really characterize the mechanism of injury. And here it was the naturally falling tree limb that killed the boy. Now, if a situation was such that maybe the landowner went out to the property, saw that there was a limb that was hanging down about to fall, and and he maybe sawed a portion of it, making it more likely that would fall down. He knew people would be sledding in this area. That may present a different set of circumstances and a different outcome, and it may give the plaintiff a reason to argue that the landowner was grossly negligent or willful or wanton. So I think the critical fact here that the court really looked to is the naturally falling tree limb, by a matter of happenstance, fell and injured the boy while he was sledding, that was certainly within the purview of the Recreational Land Use Act to be applied and bar suit. The third case that I want to talk about, a more recent case, and actually it's a case that was recently decided by the Michigan Supreme Court just a few months ago, was kind of defining what recreational land use means. In that case, the plaintiff was injured when he stepped onto some hot coals, a fire pit, if you will, while walking near a lake on a camping trip. In that case, the trial court granted summary disposition, suggesting that the plaintiff was engaged in recreational land use activity, and so his claims were barred under the statute, the Recreational Land Use Act. The Court of Appeals overturned that decision and disagreed with the trial court, holding that the plaintiff was not engaged in what they would consider, quote, other outdoor recreational use as required by the Land Use Act. As you remember, the land use statute identifies a series of activities that it suggests are, quote, recreational outdoor uses. And then it goes on to essentially say, and any other type of activity of the same kind. So the trial court believed that walking on a beach play near a fire pit was of the same kind to invoke the Recreational Land Use Act. Court of Appeals disagreed. That decision was then appealed to the Michigan Supreme Court. The Michigan Supreme Court reversed the Court of Appeals, reinstated the trial court's order granting summary disposition, and found in particular that plaintiff's activity of beach play is the same sort of activity as other outdoor recreational uses as identified in the statute. Thus, the act applied to bar suit. So I think that is a significant recent decision, and I think it kind of just, as stated earlier in this webinar, goes to the point that it's pretty broad. The types of activities that one has to be engaged in on land to be considered outdoor recreational land use is pretty broad. So just about, to me, just about any activity could potentially qualify as other outdoor use to allow a landowner to take advantage of the Recreational Land Use Act to bar a claim of injury. So again, what is the impact on landowners? If a person enters your land without paying for its use and engages in an outdoor recreational land activity, you, the landowner, are not liable, unless, of course, you've acted grossly negligent or willfully and wantonly. That is a takeaway from today, and I think, again, as previously stated, if you get a set of facts where it sounds like the plaintiff was injured playing outdoors on land, and you're representing or insuring the owner or tenant or lessee of that land, and it's arguable that the Recreational Land Use Act applies, you got to plead it. You got to put it in the affirmative defenses. You don't want to be able to lose that ability, because if it does apply, again, it's an absolute bar. It's a great defense. And especially now where people are having more parties at their home and we're not limiting the situations to large tracts of land, I can see that this is a potential bar to a lot of cases and where individuals are being injured. This concludes this webinar. I really appreciate everyone's attention. Bear with me through this long and it could be considered a bit dry area. However, I think that, again, this webinar is helpful. You may not see the ability to use the defense very often, but again, if you do have those circumstances that it may apply, it's a great defense to use. It's a good way to get out of a case early and save yourself some time, aggravation, and money. So if anyone has any additional questions, my information is on the screen right now. Please feel free to give me a call anytime, and I will do my best to get back with you as soon as possible. Thanks again.